Mike Borg. The firm is Soffer Rech Borg. We're new to Mineola. We recently left the city. Well, not so much recent anymore. As of July 1st, the firm handles three basic aspects of the practice. We do a commercial litigation practice that's rooted in collection, and I'll talk a little bit about the various type of debt there is. We do residential real estate closings, and I will handle traffic infractions in Nassau and Suffolk County. You know, the Hot Pod Court and the Hempstead Court, and then I'll follow up with the current court situation. But let's first talk about the accounts receivable issue. I know Dennis was talking about that before. So basically we have two types of debt. Okay, you have consumer debt, which is debt that comes from household use, your mortgage debt, your medical debt. Leo, a lot of your homeowner's insurance debt, the deductibles that may flow from that. That's what we call consumer debt, and it's got to be handled differently than commercial debt. If you have consumer debt, you have to bring the case. If you take it to suit, you have to bring the case in the county where the debtor resides. Okay, that's federally mandated by the Fair Debt Collection Practices Act. The action has to be brought in the county where the debtor resides, and that could be very difficult for a company that that does business in many different counties across the state, across the country. It may require the engagement of outside counsel to handle something like that. And if you're a small business person and you're dealing with whatever type of accounts receivable, professional services, goods sold and delivered, and it is consumer in nature, you might not be able to use your favorite attorney, the guy who did your house closing, did your will, did everything like that. You have to bring suit. Let's say you're dealing with a guy in Missouri. You have to refer the case out to Missouri counsel, or you can fall afoul of the FDCPA. It's a nuance that we understand, and you switch the focus to commercial debt. That's basically business to business, although some states broadly define consumer debt to encompass some commercial debt. But basically your commercial debt is, let's use an example. I'm a restaurateur and I don't pay my meat guy. So my meat guy is going to come after me for my accounts receivable bill, the accounts receivable that I owe him, and it gets bad and I stop using him and he needs to sue me. He could sue me where it is convenient for him. So if he is in Nassau County, and let's say my restaurant is in Westchester County, he can bring me to Nassau County. The mechanics of commencing a commercial suit versus a consumer suit are different as well. In the consumer realm, the attorney would have to serve a bilingual summons, not so much a bilingual complaint, but a bilingual summons. And there are some other procedural hoops that need to be jumped through, including the payment of higher fees to commence the action in certain consumer actions like credit card and other forms of revolving debt, perhaps car leases, things along those lines. I'm not even going to go into the nastiness that phone calls and text messages and things like that entail, because we don't really do that. That's not my forte. That's a high volume collection agency type of situation, and they typically have auto dialers. And I was at a convention in Miami a few years ago, and they actually have a software application that can place a voicemail on your phone without your phone ringing. And it just boggled my mind how they get around that, the phone ringing aspect, and just put that voicemail there. So you're sitting, you're doing your thing, you look down, oh, I got a voicemail. Was it the kids? And the creditor is in your face. That kind of frightened me, because I see that as possibly ripe for a huge class action suit brought under any number of federal statutes, the FDCPA, perhaps the Fair Credit Reporting Act. Now, to me, these are all issues and reasons why I try to stay away from a high volume of consumer debt. Just too many hoops, too many procedural hoops, and the downside is very high. And as a matter of fact, my professional liability policy, they have a question as to the type of debt that I handle, and they're not sophisticated enough, at least in these applications, to know the distinctions. So I can't just check a box. I mean, I actually have to write on the application that while I do debt collection work, it's all consumer. It's all commercial. Zero consumer. I think one of the last consumer cases I handled was for my wife's dentist. She's a hygienist, and the guy that she works for had somebody owed him about, I don't know, $5,000, and it was a headache. They ultimately went bankrupt. Before that, one of the patients died, unrelated to any dental work, and the surviving spouse actually put the property into bankruptcy, and nobody got anything. So let's see. That's the collection aspect, and the litigation. Well, that's the collection aspect. The litigation aspect, I view it as more of a chess game type of a situation, and I have to play better chess now than I've ever had to play before, because of the way COVID has shut down the court system and has, up until yesterday, prevented me from entering judgments. Now, I don't know. I haven't looked. I've been having some internet problems. I can't connect to my office. Otherwise, I might have even had more to talk about. But there was an executive order that came down, I believe, on October 5th, that lifted all of the procedural stays based upon the emergency that was declared back in March with respect to COVID. Now, as of the first week in October, and again, I don't believe it's been rescinded, changed, or extended. I can now enter judgments by default on defaults occurring after March 20th. So that remains to be seen. I think it'll fly. I don't know how long it'll fly for, depending upon how the election goes, because somebody wants to shut things down again. And that could present an issue. But when I say you can't enter a default judgment, I mean just that. There's a specific CPLR, and those are the rules that we live by. There is a specific CPLR provision that governs that governs default situations. Served with a complaint, don't answer, judgment. There are other types of judgments that I can enter. Judgments by confession, judgments based upon a broken stipulation of settlement, judgments by court verdict, or other judges' decisions. And those I have entered in the past, well, fairly recently. So what I try to do when I'm speaking with people, and here's where the chess comes in, when I'm speaking with people about their case, when I get the phone call or the email, what I try to do is put them into an agreement, a payment arrangement that will allow me to enter judgment in a manner in which the courts are currently allowing, and even with all of the COVID stays that were in effect, I can get around that. And you know, sometimes it's worked, sometimes it hasn't worked. You know, basically what it boils down to is you just have to know what works and know what doesn't, and know what doesn't work. And, you know your, I don't want to call them shortcuts because that kind of sounds nefarious, but just know the loopholes and the ways to get things through. And I'm sure it's the same way, you know, with trusts, with matrimonial, you know, the more experienced attorney, the more experienced practitioner who has seen it all before, or has seen a lot of it before, because you've never seen it all, because every time you think you've seen it all, somebody comes along and throws something else at you, and it just makes you scratch your head. But the more experienced the practitioner, the better off the potential client is. Okay, so that's pretty much the litigation aspect. I'll talk a little bit about my real estate practice. You know, basically residential, buys and sells. You know, I'm sure I can echo what Linda has said. I'm seeing people coming into my office getting over ask when they're selling. I have a couple of cases in the works where people are leaving New York. One in particular, a good friend of mine, is moving to Florida. He flies for airlines, and the aircraft that he flies is the I think it's the 767, which is like their second or third largest plane. And he basically flies out of New York or Detroit. And he's moving to Florida. He says, I don't care about the commute because, you know, I can fly for free. So, you know, he can jump seat on a plane, you know, several hours before or whatever the required time is before his scheduled flight. He can get to New York and do his thing. And the beauty of what he's doing is he's eliminating the New York State income tax because he's now a Florida resident. So, you know, that works well for him. So one of the new things that I've had to deal with, or that any real estate attorney has had to will have to deal with today, are the COVID riders. Now, my first, I'll call it post-COVID deal. I had no idea what was going on with these things. So I'm talking with a couple of colleagues, and what I've learned is, you know, it's selfish on the part of the people involved in the transaction, but a seller doesn't want to give a COVID rider. They don't care. They want their deal to close. I mean, unless you're in a pine box and, you know, the closing is November 15th, we're closing on November 15th, or I'm going to send out a time is of the essence letter and, keep your deposit for breach. Something to watch out for, something to think about. So if you're a seller and the buyer insists on a COVID rider, you want to negotiate to the point where the COVID rider is mild as compared to, a complete out. Again, just some of the nuances that the kid out of law school who's going to do a closing for $500 or $600 might not know about. And I used to call them the Craigslist people, because I used to see these guys looking to do closings for $350, $400, $500 on Craigslist. And, you get what you pay for. You'll never speak to anybody on the phone. Your attorney will, he may not even be at the closing. He may send somebody. He may send somebody to the closing with the appropriate docs, the signed checks, whatever he needs. But again, you get what you pay for. And in terms of a $500 or $600 closing, the old timers, and unfortunately, I guess I could lump myself into that now. You can pay me now or you can pay me later. Because if I have to come in and undo issues that were created by somebody who is less, I don't want to say he's stupid or she's stupid, but they just don't have the experience and they're a little bit naive. I mean, I remember my first closing. I had a title guy, and I took him aside and I said to him, I said, look, this is my first closing. No point in lying about it. This is my first closing. You get me through this and you'll have my business forever. And he did. And that's an important thing. So there are some nuances in real estate. Let's go down the list a little bit. Speeding tickets, traffic tickets. It's, again, if you've got a clean license, it's let's make a deal. You need to have somebody go down, speak to the people, because if you plead guilty and just hope for the best, you're going to wind up paying the maximum fine allowable by law. So there is a lot of we're not magicians, but we certainly can be damage control experts in those situations. You're going to pay something. It's just a question of how much you want to pay and what the trade-off is between paying money and getting points. And I mean, I know what points are. I know how they total up, but I'm sure Leo can tell you what points are going to do to your premium. I know they're going to go up, but at what scale, I don't know. So at this point, I think it's best to unmute everybody and take some questions. If there are any out there, if I haven't bored you all to tears.